here today. I'm going to talk to you today about blockchain from a compliance perspective with data protection and data privacy law. And we can understand what does personal data on blockchain mean from the perspective of the policymakers. So blockchain is a general purpose ledger data management and distribution technology that secures data by methods of cryptographic proof, and basically it can represent anything that we believe it can represent. It can represent goods, services, and any sorts of assets and entitlements. So we are seeing the examples of it in forms of all the different forms of digital money and mobile banking and tracking the ownership of financial assets on blockchain. We see that they're happening, and we already know that different sectors in the economy are trying to use the new technology in order to secure trust in the network and kind of reduce the old world problems that we had with record keeping, concentrating record keeping in one point of failure, one gatekeeper, or trusted intermediary parties that they were supposed to provide the security and integrity of data for us. So this new technology provides a decentralized authority that basically verification of data and its securities is provided on a peer-to-peer basis and to a trust in the network that we are creating. And verification is happening actually by crowdsourcing, basically. And it's a perfect, actually, environment, a very smart environment that provides for identifiability of data and brings a lot of transparency. That's why also the public sector is very interested in using blockchain for securizing different infrastructure against cybersecurity attacks and, for example, also for transparency, bringing transparency in terms of operational and budgetary activities, and also tax evasion, tax frauds. They can basically trace better by using this new technology. And of course, it is resilient to replication. We know that the data is basically stored on multiple and several computers, so even if one or several of those are failing, still the data remains unaffected. And we all are hearing about all these good things about blockchain. It's tamper-proof, it's irreversible, immutable, and appendable. Appendable meaning that they are purposefully designed to basically make any unilateral change or modification or deletion of data extremely burdensome. So by doing that, you're bringing integrity to the data and trust in the network. So, and also we know that blockchain and AI converge and they have accelerating effects. So smart contracts embedded with AI execute transactions on blockchain, process payment, trace goods and ownership of financial assets, and even resolve disputes and bring visibility to intellectual property, for example, and they have an amplifying effect on each other. They accelerate each other when they converge. So now let's take a look at personal data ecosystem. When we're talking about blockchain, why we're talking also about the personal data. The individual is at the center, and the way we communicate our information, personal data, personal information, whether they relate to our public life when we're doing transactions, when we are engaging in financial, when we are purchasing, transacting financial assets, or even when it relates to our personal life, we voluntarily share our information on profiles, etc. What does this mean for the consumption and for businesses? Why businesses are interested in this personal data that relates to this individual? Of course, the consumption for business and commercial purposes are evident. They are using them for advertisement, for market research, for data exchange, and also for tracking financial assets. And that is why that nowadays we refer to personal data as the new oil for the economy. And a new class, a new asset class in our economy is the personal data. So now let's get to the blockchain and see what is considered to be personal data on blockchain. And and as a general purpose, it can be used for any sort of, in any specific sector of the economy. So any data that directly or indirectly relates to an identified or identifiable natural person by reference to any sort of identifier such as name, address, location, and other factors such as economic, cultural, or even social identity can be inferred or related to an individual on blockchain is considered to be personal data. So on blockchain, we already know that public key is the personal data. So we know that the public key is a string of letters and characters that is encrypted, is hashed, and by its face, when we look at it on its face, it doesn't refer to any specific person. Basically, public keys are best understood as being your account number that you share when you are transacting. And of course, everybody has a public key and a private key on blockchain. The private key is known better, if you, by way of analogy, you can refer to it as a password that you have. Again, a string of letters and numbers that there is an interrelation between the public key and private key for advancing any transactions on blockchain. So private key is what can decrypt what has been encrypted by the public key. So any addition of, and also another thing that can be considered as personal data and asset on blockchain is transactional data. So addition of any initial addition of personal data on blockchain and then continuous storage on blockchain and processing, further processing, is considered processing personal data. So why it is important? Why do we talk about these personal data and we think that, of course, they are pseudonymized and what we're seeing is only numbers and characters? What is important to know from the legal perspective, we already know, and the policymakers, we already know that pseudonymization does not irreversibly make the data anonymous. This is for fact. We know that the law enforcement authorities, legislators, can absolutely ask the corporate insiders to disclose their public keys and digital wallet identifications under the penalty of law. And above that, we know that the hackers have already been able to rehash. So we have the examples back in 2016 with the Ethereum, for example, that a big hack occurred, and of course the members of Ethereum, the miners, were able to basically, by using a hard fork, stop the hack from the point of hacking forward by basically negating the theft by the hackers and negating the unanticipated consequences of self-executing smart contracts. However, we know that these hackers already have rehashing from the perspective. I'm not a tech person, but I know that rehashing is apparently a fairly easy procedure for hackers, and they already have come up with a rainbow table of all the possible combinations that they can rehash data and relate it to the individual and crack the network and divert assets. So these threats exist, and basically anonymization is not even something that is favored by lawmakers, because lawmakers and policymakers definitely do not want the data to become completely anonymous in a way that there is no way you can relate it to any person, because of all the fraudulent activities that can happen. For example, nobody favors in the law circles to create a cryptocurrency based on a zero proof knowledge that basically makes it completely anonymous, and there's no way that, it provides grounds for fraudulent activities, for tax evasion, for financing terrorism, for money laundering, etc. So from the law perspective, still pseudonymization and sufficiently kind of like contributes to the safety of the personal information on blockchain. However, there is always this possibility in the technology sector, by singling out linkability and inferences, that we can get through the public key or any personal information related to transactional data to the individual users of these networks, and there are potential threats there. So, and to add to this spectrum of concerns from the law and policymakers' perspective, we are approaching this quantum computing age, and National Institute of Standards and Technology, they are already working hard and providing equations that saves the data from the prying eyes, and we know that the calculations are going to happen when the quantum computers are coming. It's going to happen completely different from the conventional computers. And what is important for hackers, there's a famous saying that says, harvest now, decrypt later, meaning that, again, going back to the fact that personal data is a new asset class, and there are the very, very valuable assets in the market nowadays. They can harvest and unmask the data today and decrypt when the technology allows. So now let's dig into finally to what do we have from the legal side. What has already been done with regards to data protection in law and what is ongoing. So historically, data protection has been seen in two different spheres. First, the data privacy, that laws that regulates and controls the collection, use, and dissemination of personal data of individuals, and then data security that mainly protect personal information from unauthorized access, or the ways that you can respond to that unauthorized access. What we are now witnessing is that in the context of Europe, we have a general data regulation protection that already has an extraterritorial and global outreach, meaning that all the American entities, business entities, are also affected by this regulation. So any business entities established within the EU or even have no presence in the EU, however, they offer goods or services to individuals within the EU, or they monitor the behavior of individuals in the EU, no matter where the processing and collection of data is occurring, will be subject to the GDPR. And if you are interested, you can take a look at the US ITC, International Trade Commission, annual reports of the number of fined companies, American fined companies, according not being compatible, not being in compliance with the GDPR because of the lack of security requirements, lack of requirements under the GDPR for data minimization and purpose limitation, and also failure to get consent from data subjects, from individuals, before they collect and process data. What sort of technology you use that touches upon the personal data, you're going to be subject to the to European General Data Protection Regulation. Within the US, and so that law, we consider and categorize that law as being a prescriptive model law, meaning that the law itself ahead of time in a preventive way basically defines and provides all the rules and regulations for businesses to follow. On the other end of the spectrum, we have the US, which originally and traditionally has this outcome-based model law that does not interfere very much with how the businesses are doing. However, they're only going to measure the success of the business by looking into the reports and seeing whether or not the business has been successful in providing for security of data and protecting the privacy of the information. So historically, it has been very sector specific, the laws, and also types of data have been regulated within the US, not all sorts of data. And US always favors, free cross-border data flows, and it's a combination of state and federal laws such as FTC Act, Section 5, HIPAA, Gramm-Leach-Bliley Act that relates to financial institutions' use of non-public personal information in their services. And we have agency oversight. Agencies normally monitor, such as FTC or SEC, for example. However, as you're seeing, there are new trends in the US as well. So since we have been already affected by the GDPR, and the business companies here, the business entities here have been affected, so there are new trends in the policy sector in the US that they are favoring data protection, these umbrella laws that actually are becoming more and more prescriptive rather than being outcome-based. And there are bills that are now introduced at the Senate and the House that they are reviewing more comprehensive data protection regulations. So let's see what GDPR asks us to do. So first of all, any personal data going on the blockchain, you have to get the consent of data subjects, and you have to use it only for legitimate purposes. You have to minimize data for the purpose that you're using it, and there are certain data privacy rights that are given to, are provided to data subjects, the individuals. First of all, their right to access their data. There always have to be somebody that can give you access to the data that is being used. And the right to explanation, meaning that the business entities that are using your personal data need to explain to you why they are using your data, and you have a right to rectification and even demand for its erasure altogether. So when we talk about the right to erasure, there is immediately a contrast, a conflict with what we talk in blockchain that is only append only. It's supposed not to be reversed. It's supposed not to be, so you see the tension between the law and the technology that is supposed to make any changes in data already impossible. So what can be done for the compliance? So of course, technology has been thinking about it, and private entities are thinking. So there should be private measures that is actually mandated by law. There should be channels of communication between the data subjects and controllers and processors. Companies need to have data protection impact assessment within the structure of their governance and policy and procedure frameworks. And then they have to think about corrective measures ex post when they collect and process data they need to have in place. They need to provide for these rights of individuals access, rectification, or even erasure of their data from the blockchain. And from the technology solution, we already see that there are a couple of things that have been introduced. For example, adding noise has already been used within the blockchain, or different thinkings about the technology solutions that are being provided, like editable blockchain that are forgetful by their design, so that they can forget after the processing is over, and there's no need to keep the data anymore on the platform. So anyways, moving very quickly to the two bills that are now in place. There's one introduced at the House. The Congressman Frank Pallone is behind this bill, and it's in the Energy and Commerce Committee at the moment. It's been introduced, and it has a bipartisan support. 53-2 has asked it for continuing the bill. So the bill is exactly like what GDPR provides. So the same type of rights are supposed to be provided to individuals, the same sort of security requirement for affirmative express consent of the data subjects. And what is very important, of course, this is like law, but what is very important is that the compliance and enforcement is supposed to be given to the FTC. And attorneys general, and it provides a civil right, private right of action, meaning individuals can ask for, can bring this case before the federal court for any breach of their data. And it preempts all the laws, state laws, jurisdictions. It also creates some sort of clashes, especially with California, because California has this Consumer Privacy Act that is very comprehensive and very similar to the GDPR, actually. The other bill that has been introduced in the Senate by Senator Gillibrand is the Commerce, Science, and Transportation Committee. And this one actually takes away, because giving enforcement rights to FTC has a lot of issues from a legal perspective that if we have time, we're going to talk about it. But this act actually creates a new data protection agency at the federal level and takes away all those jurisdictions from the FTC to be moved to this new data protection agency. And it is important from that perspective. So issues, I don't know if I get like 2 minutes to talk about it. There are law enforcement issues with FTC. FTC does not have jurisdiction over many business entities, common carriers or non-profit organizations, federal credit unions, or banks are not subject to the jurisdiction of FTC. On top of it, FTC has some limitations on how they can fine the organizations that are in violation of the law, and because of the cease order that exists. And also there are other issues such as they're not falling under the auspices of the Administrative Procedure Act's notice and comment when they want to regulate. So regulating federal that's going to be a problem with federal FTC, basically. Private right of action has problems with Article 3 standing because you need to be harmed, and whether or not your data, nobody got a consent from you for putting your data on a blockchain that actually harms you, like physically harms you, so that you can have a scan would be okay. So then there are other issues, we can talk about it, but what I wanted to wrap up with is that you are doing business day in and day out. You are supposed to be the ones that are working with this technology. We are already witnessing a changing tide in the protection laws and enforcement, the regulations and enforcement. And you need to keep this conversation going, whether or not you see these solutions, these laws, when they're prescriptive and they're imposing additional regulations on the technology. Would that be actually create any values or takes away the value of the technology?